Welcome to the Real Estate Espresso Podcast, your morning shot of what's new in the world of real estate investing. I'm your host, Victor Manash. If you're loving what you're hearing on the show, go ahead and tell 2 friends today. Show them how easy it is to subscribe to the podcast. The Real Estate Espresso Podcast is available on more than 20 different platforms. However you listen to podcasts, you'll be sure to find it. On today's show, we're talking about government overreach, which has been partially stopped in at least one instance. Municipal governments all over North America are trying to implement rules to improve the quality of rental accommodations in their cities. One of the methods is called proactive enforcement. That's code for inspections. The theory is that if landlords know their properties will be inspected, they'll have a stronger incentive to make sure their property complies with the building code and the property standards that make a property considered to be inhabitable. Not only do things need to be in working order, they also have to be safe and free from health hazards like molds and other toxins. You would think that if the goal is to improve the quality of rental properties, then the tenants who have the problems of their rental units would favor these inspections. Well, in the Commonwealth of Pennsylvania, that rule just got challenged in court. Back in June of 2015, the Borough of Pottstown, Pennsylvania enacted a number of housing ordinance amendments. At issue here, the amendments included provisions requiring each owner of a rental property to permit inspections of all rental units every 2 years. If voluntary access for an inspection was denied, the ordinance allows the borough to apply for an administrative warrant. The new rule doesn't disclose what criteria, if any, the borough must satisfy in order to obtain such a warrant. In the case before the court, the tenants and the landlord refused voluntary access to their rental units by borough inspectors. Pottstown tenants, Dottie and Omar Riviera, and their longtime landlord, Steve Camburn, refused to allow inspectors inside the home. Pottstown then obtained administrative warrants to search inside, but with no suspicion that anything was wrong. The borough also attempted to search non-rental family home of Pottstown residents Thomas, Kathleen, and Rosemary O'Connor, without their consent and with no search warrant whatsoever. These brave citizens sued Pottstown with the help of the Institute for Justice. The Commonwealth Court earlier this week overturned the lower court's ruling in favor of Pottstown in a lawsuit that challenged the borough's rental inspection ordinance. The lower court upheld the right of the borough to enter residents' homes without cause and without the residents' consent. Tenants in the case asserted that the use of administrative warrants is unconstitutional because such warrants are issued without requiring any individual probable cause to believe any building code violation exists. The tenants also pointed out that each inspector is instructed to share with police any observation of an item in the rental unit that the inspector, in their sole discretion, considers an indicator of criminal activity. This effectively gives police the ability to obtain information about the contents of a dwelling without the need for a search warrant. The tenants also argued that the privacy protections under the Pennsylvania Constitution are more extensive than the protections under the U.S. Constitution, governing individual rights of privacy and freedom from unreasonable search. The article in the Constitution says, and I quote, "The people shall be secure in their persons, houses, papers, and possessions from unreasonable searches and seizures." This language is similar to that of the Fourth Amendment of the U.S. Constitution, but it provides broader protection than the Fourth Amendment. In June of 2018, the borough filed a motion for judgment on the pleadings, and they argued that the inspection provisions of the housing ordinance were not unconstitutional. And then on Monday this week, the judge in the appeals court who heard the case ruled in favor of the landlords and tenants who opposed the new rule. Judge Ciesler's ruling said, to require tenants to endure inspections before challenging the inspection would require and render Tenants Article 1, Section 8 privacy rights illusory. Essentially what the judge is saying is that Pottstown rental inspections regime was a way to get around the constitutional protections for privacy. This ruling could ensure that every Pennsylvanian who resists a search of their home can only have the government enter with a warrant supported by probable cause that something is wrong inside. The trial itself was full of drama. The tenants demanded a lot of information in the discovery process to prove their point that the searches were an invasion of privacy, and the trial court denied the tenants' motion for the borough to produce that documentation. The court concluded that information relating to people who were not parties to the lawsuit was irrelevant and therefore inadmissible. So this week's ruling is definitely a small victory for privacy rights and a great victory for tenants and landlords. As you think about that, have an awesome rest of your day. Go make some great things happen. We'll talk to you again tomorrow.